Hi, Tony DeWitt here, Missouri Appellate Attorney and a guy who likes to make the law make sense on YouTube. Today we have a question, and I would appreciate your input and your vote on the poll that's going to be posted right after I post this video. For those of you who may have missed it, YNW Melly, otherwise known as Jamel Demons, was arrested and charged with first-degree murder in the death of his fellow rappers. Prosecutors say Melly, after a late-night recording session, shot Christopher Thomas and Anthony Williams inside an SUV, and he and Cortland Henry then tried to make it look like a drive-by shooting. The 24-year-old rapper was jailed without bond, and he was brought to trial earlier this year after a long and contentious period of pretrial work. Then the trial was long and contentious, where he was, I think, very ably represented, and the jury could not reach a verdict on his guilt or innocence. Essentially, it was a 9-3 vote, 9 for conviction, 3 to acquit. This usually happens when there are folks on both sides that won't budge from their position after extensive deliberations. And this is what we want to happen in a criminal trial. If a jury is not absolutely convinced that someone is guilty, they should not vote guilty, and they should stick to their guns to the bitter end. Unless, in the course of deliberations, they come to see what the other jurors see. But it only takes one juror to hang up a jury. Now, because there was a hung jury, a mistrial is declared and the case has to be retried. This is burdensome both on the defendant and on the state, although obviously more so on the defendant. In the midst of all this, one of the prosecutors came forward and said that she heard one of the detectives essentially suborn perjury in the execution of a search warrant. But she didn't reveal it before the first trial. She held this back until the end of the trial. Then she filed a Brady notice on the issue and disclosed it to the defense. Now, this involved Detective Moretti, and evidence taken from Moretti in a deposition made it clear he did not try to get the other sheriff's officer to lie. Moretti said that he told the state's attorney that Gorell, that deputy, made a joke, and that was it. The assistant DA, however, said that after Moretti executed a search warrant for Jamel Demon's mother's phone, Deputy Adam Gorell arrived at the conference room, and Moretti allegedly made a comment to Gorell about saying he was present while the search warrant was executed. Gorell jokingly said, "I can be anywhere you need me to be." Prosecutors say the exchange between Moretti and the deputy was a joke, pointing to the fact that an attorney for Demon's mother was present when her phone was taken and would have known the deputy wasn't there. The logical argument, however, did not carry the day. Because Moretti's account differed significantly from the account of the assistant DA, the lead prosecutor, Christine Bradley was removed from the case because she can now be called as a witness by the defense in an attempt to impeach Moretti and make him out to be a liar, and thereby to ensure that the evidence obtained from the phone is suppressed at trial. But this past week, according to sources, an entire panel of jurors was struck by the judge in an effort to ensure a fair trial. Here's what happened. The defense made a misstatement of law in their voir dire. One of them said the prosecution had to prove not only that Demons killed the two rappers, but that he was a member of a street gang, and those both had to be proved beyond a reasonable doubt in order to convict him of murder. But that's incorrect, because to convict him of murder, they only need to have to prove the elements of murder beyond a reasonable doubt. If they can't prove the gang affiliation beyond a reasonable doubt, that just means the gang enhancement is lost on the sentence. The state objected to the incorrect statement of law, and the judge told the attorney to rephrase. But then when he rephrased, he asked the same question again. The state again objected and asked for the court to read the jury instructions to the jury panel. The defense then moved to strike the entire panel because if the court proved up the incorrect statement of law to the jury by the jury instructions, the jury would lose all respect and the defense counsel would lose credibility with the jury. So the defense screws up twice, gets corrected once, and before they can get corrected twice, they whine about looking bad. But here's where having a really good trial judge is a really good thing. The trial judge is not going to hold the defense counsel's blunder against the defendant. Even though the jurors were capable of being retained because the court did not rebuke the counsel in open court, the court still granted the defense motion and struck the panel, meaning the 2 days of questioning by the state prior to that must now be repeated with a brand new jury panel. Well, there are multiple evidentiary matters that need to be taken up here, and there are multiple issues that have been briefed by both sides. As you might expect, the actual documents filed by the state and the defense are not available on the public docket. DeMond's first murder trial, as I said, ended with a 9-3 vote for conviction. In this case, he faces a possible death sentence if he's convicted of first-degree murder in these 2018 murders of his two childhood friends, Christopher Thomas and Anthony Williams. Their stage names, YNW Juvie and YNW Sack Chaser, all include YNW because they belong to the same hip-hop collective. It stands for Young New Wave, or perhaps the N-word stands for something else, a word that should never be used. Because the death penalty is on the table and because the first vote for conviction was 9-3, Melly's lawyers have their work cut out for them. And they have to be very careful not only about maintaining their credibility, but also about what motions get filed and reported on in the press. Sometimes pretrial coverage, even though it's protected by the First Amendment, runs afoul of the defendant's protections that are afforded to him by the other amendments in the Bill of Rights.
Hey folks, please excuse the interruption, but let me ask you if you would, if you haven't already, please subscribe, and if you would, hit that like button and maybe even leave a comment. That tells YouTube that this is a valuable video and they'll refer it to more people. It helps me out a lot and I appreciate it. Thank you.
Getting a jury is going to take a lot longer. They're currently working on it. They'll be working on it through the end of December. Literally hundreds of people were summoned for jury service. Of them, doubtless more than a few have heard of the case. And some of them may have even tuned in gavel to gavel on court TV. Or, knowing that they have been summoned for this jury, they might very well have gone back to court TV or Law and Crime and looked at the trial. So finding someone who can be fair and base their decision on the evidence presented in this case and disregard the evidence from the first case is a monumental task, not only for the defense attorneys, but also for the state, because you have to seat a constitutionally permissible jury. And that requires an extensive voir dire, and it requires efforts on both sides to play fair. And while it may very well be that it was just a slip of the tongue in the original voir dire that we talked about, it could also be some gamesmanship, and sometimes that happens in criminal cases. They find 7 or 8 people in that jury panel whose demographics are such that they know they will be prosecution friendly, and all of a sudden the jury panel has to be stricken. Now, I'm not saying that's what happened. I'm just saying that that is a possible reason why they might have tried to get the jury panel struck. As I pointed out in my video on voir dire, or jury selection, it's all about getting people to admit what their biases are, and then getting them to determine whether they can be fair, whether they can put aside those biases and judge the evidence that comes into trial. Put on a set of blinders and not see the evidence that was admitted in the prior trial or what they've read in the media. Because you start with something around 500 people and you have to whittle it down to 16. 12 jurors and 4 alternates. Now to get there, in order to get to a place where you can whittle it down to 16, you have to have a pool at the end of the day equal to at least 40 qualified jurors. Once you have that number, each party gets 10 peremptory challenges where someone can be removed for any reason or no reason, but not for a discriminatory reason. So the state cannot strike all the African Americans on the panel without a race-neutral explanation. You know, she wasn't paying attention during trial. She didn't respond to any of our questions. She sat there stone-faced. We couldn't determine whether or not she was listening. Those are race-neutral explanations, but if you strike all of them, it looks kind of suspicious. So peremptory strikes on both sides are required to be race-neutral, but this is usually only enforced against the state. The reason you start with so many and work down to so few is that many people will already have formed an opinion on guilt and cannot put it aside. Those are going to be the people who are struck for cause. Now, some of them may give equivocal answers and they can't definitely say that they can be fair, the court will strike them. The Melly case is a case that will be won or lost in jury selection, which is why the judge's decision to strike the entire panel was a good one. If you start with no credibility, it's difficult to recover from that, even when it's your own darned fault, and that inures to the detriment of your client, so they did the right thing by asking for that relief. This case really comes down to forensics and timing. In my opinion, none of the evidence squares up with the timeline that Melly asserts, but it does square up with the prosecution's theory of the case. One of the issues in this case is whether or not it was a drive-by shooting or whether they were shot from inside. Well, bullets make different shapes when they pass through metal, and if the bullet is fired from inside the car, the bullet hole on the outside of the car will have metal protruding outward. These are the items of evidence that the jurors can see with their own eyes from their own experience and use their common sense to figure out what happened. And that's what's going to be at issue in this trial. Now, the start date has now been pushed back to February 5 because Christine Bradley was removed from the case, and they need to get new prosecutors in and up to speed and develop some trial planning and that sort of thing. In the next few months, there'll be a lot of motions decided and a lot of issues preserved for a later appeal. Or if it goes against the state, what may happen is the state may wind up filing a writ or an interlocutory appeal to determine whether or not the trial court has made an error. There are a lot of moves and counter moves that you're going to see leading up to this very important trial. Now, for that poll question, do you think YNW Melly can get a fair trial? Please let me know what you think. Vote in the poll and then leave me a comment, and perhaps we'll do a video looking at those comments here. You can always email me, and of course, if you email me, I will not reveal your email address to the world. So that's what I have for you today. If you have the opportunity today, please try and do something nice for someone. At this time of year, there are a lot of people who are not going to have a lot of money to buy a big feast for Christmas or Hanukkah. And it's a good time to donate what you can to your local food bank and help someone else have a Merry Christmas. Thanks again for being here. Thanks for watching my video. And come back and see me tomorrow. We'll talk about something else interesting.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.